Hello, everyone. Harry here to talk about why the delay in the opinion from the DC Circuit on Trump's immunity claim is worrisome, even beyond the passage of days as we wait. So there was an article yesterday, a good one that made the rounds by Kyle Cheney and another author talking about, 50 days have elapsed and just adding that on and to the trial date that is now clearly gone by the boards. In fact, Judge Chutkan has taken it off her docket of April 4th and just kind of transplanting the duration of the time until they decide onto that and analyzing what impact it might have on the case and whether the case is viable to go forward before the election and the prospects that it actually begin in the heat of the general election and the like. All true, but actually understates the problem. And here's why. I think it's actually more worrisome than that. Recall January 9th, I think, and the actual oral argument in front of three judges, Childs and Pan, who are appointees of Biden, and Henderson, an appointee of George H.W. Bush, the senior judge and the presiding judge. At the time, it was a pretty active argument where it was clear on the one hand that all three of the judges would reject Trump's outlandish claim, especially at oral argument. It was stunningly broad, and a question by Judge Pan completely exposed it. But the claim was basically, you can never prosecute the president for anything arguably within official sphere. And the hypo by Pan was you take the Navy SEALs and order them to assassinate your election opponent, unless there's been a impeachment of the president and a conviction of the president. I won't go into that convoluted argument, but when you push on it, it looks as bad as or worse than when you address it superficially. It just makes no sense at all. And that was clear from all the judges. However, they were really exploring different reasons. There's not a case law on presidential immunity from criminal process and, criminal indictment for good reason. It's never happened. And they have to be aware, they're the second most important court in the country, and then there's the Supreme Court potentially coming, that, it's not just for Donald Trump that they're resolving this case. So you really saw 3, 4, 5 different lines of possible ways of conceptualizing or rationalizing why Trump doesn't get immunity here. By all three of them, and then in particular a line by Judge Henderson that had to do with the take care clause under the Constitution and why and to what degree that would provide for some measure of immunity, but not immunity that would cover Trump. The danger here goes two ways. First, there's a particular danger, or which increases over time, that Judge Henderson is writing separately. Remember, the DC Circuit gave a briefing schedule that was super quick, warp speed, boom, boom. And when they've done that in the past, they've issued the opinion very quickly, like within a week or two. So the people who are saying, oh, this happens in courts of appeals and they're just taking their time and being methodical are missing that all important point. We would have expected it otherwise. So Judge Henderson's the senior judge. Let's say she's writing an opinion that differs from Childs and Pan. If it's all the same, that's sort of part of the second scenario I'll get to. But let's say Childs and Pan have already written, we're ready, within days, and now she's writing on her own, what I think would be technically a concurring opinion saying Trump loses, but for importantly different reasons. That, when you think about the 6-person conservative and the 5-person uber conservative majority on the Supreme Court is worrying, because her particular line might be something that the conservative majority is really attracted to and wants itself to take the case and affirm her way of thinking about it. Not again who wins, but her way of thinking about it. And with Trump, and now there's always what are the merits and what effect on the all-important clock and delay. Supreme Court taking this case, even if it were trying to do it quickly, which it might or might not, would, ordering briefs, having argument, etc., would leave the question unsettled for a long time. I think too long to have the case go forward. And remember, the whole point here is he gets an interlocutory appeal. He's able to bring this up before and have it resolved before the court goes to trial. So that's the worry on that side. Let's go back to the first possibility, which is Childs and Pan and all three of them are writing, but they're doing something that's a little nuanced and a little different from Chutkan, who just said very broadly, I reject his claim that he always has, and I'm not going to go into deciding now, is it within the outer perimeter or whatever, but his claim is all wet, and so no immunity, and let's get on with it. If they do something that is nuanced and disagrees with her, Judge Chutkan, in part, and remand the case so that she can apply the accurate law. Remember, they did this in the gag order situation. Chutkan imposed a gag order. They thought it didn't allow for enough First Amendment protection in a couple little ways. Didn't let him trash Jack Smith, say. They said, and they remanded it to Chutkan, and she simply applied what they said. The worry, though, is if something just like that happens, Trump, can appeal that remand with some completely spurious phony baloney argument about how Chutkan's application of the remand doesn't fit or doesn't quite follow their instructions. And it's just not clear to me. You could imagine the courts fashioning it so it doesn't happen, but offhand, an appeal is an appeal. And when you're in this immunity setting, and pretty much only here for purposes of this trial and the whole legal landscape with Trump, this is his big, not get out of jail free card, but delay going into jail free card, because of immunity gives him this delay while he gets to appeal it. And that freezes the linebackers back in Chutkan's court. She can't start the trial. So the worry on one side, Henderson says something and the Supreme Court dives in. The worry on the other side is they say something that's different from Chutkan. They remand it. Chutkan applies the remanded guidance, but Trump then appeals with very, spurious claims. Now, the courts would make quick work of that, I think, very quick. But nevertheless, there's a minimum that's added on now of an additional delay. It's hard, as you do the calculations, to think of it as less than a month. And a month's a long time in the calendar that we're talking about. As the clock ticks on what should have, by expectations at the time, been an opinion issued a few weeks ago, the worry is not simply, as people have noticed, a day here of delay is a day in the trial's commencement. That's all true, but it might augur even more delay as courts get into the action. Either the Supreme Court may be being interested in the case, or Chutkan on remand, then and Trump then appealing. That to me is the whole package that has to be considered, and why indeed the delay of a few weeks now, as we're waiting for this opinion, really is of real concern. This is the case, the 1-6 case. That's most important, most sort of addresses his wickedness as president, and I think most likely to go forward because of Chutkan and other reasons. So this and the immunity question is the one thing that keeps it out of her ability to push ahead. So the worry here is even greater than the days elapsed, which of course is nothing as significant in and of itself, and each day, clicks another day away from when we can begin the trial. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.